Commission Against Corruption via video conference. For the Hansard record, will you please state your full name and the capacity in which you appear today?
My name is John Hatzistergos and I'm the Chief Commissioner of the New South Wales Independent Commission Against Corruption.
Thank you. I now invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions.
Madam Chair, I don't propose to make a detailed opening statement. I'm happy to leave it to members of the committee to ask me questions. The only thing I would like to do publicly is to acknowledge the work of Commissioner Paul Brereton, who will shortly be departing from the National Anti-Corruption Commission, and also Deputy Commissioner Nicole Rose. We've had a number of initiatives where we've worked cooperatively together. They're detailed in our submission. I thank him for his work in that regard and the work of the other Deputy Commissioners, and I'll do my best to continue to work with the staff of the National Anti-Corruption Commission for the duration of my term.
All right, thank you. And we have heard from other witnesses and in submissions about some of the work that you undertake, particularly I think as what I believe is the oldest anti-corruption commission in Australia. So we are particularly grateful that you made a submission to this inquiry and are appearing today so that we can draw on the experience that you do have. In your written submission, you refer to the support mechanisms for witnesses and other people and the approach that the ICAC has adopted in that space, including the fact, I think, that you've made some changes to that process. Could you talk us through those changes, why you made them and why you think they're important?
Well, we had a number of tragic events. As some of your participants would be aware at the Commission, the inspector, upon assuming her role, decided to do a investigation in relation to the question of witness welfare. I might add that there had been other incidents in some of the other jurisdictions as well. On the back of the recommendations we were made, we established a witness welfare officer. We established a referral process for witnesses who could benefit from that. We also undertook a comprehensive program of mental health training throughout the Commission, and I've undertaken that training myself, as have my colleagues as commissioners. We've got new processes to deal with that. We've shared our approach with other jurisdictions around the country. A paper was prepared by a couple of the commissioners from other agencies. We reflected on that paper, which documented best practice approaches across the nation. And as a result of that, we also made further modifications to the approaches that we take. So it's an issue that we take very seriously, not only because we want to protect the health and welfare of people, but we're also anxious, of course, to get the best possible evidence.
Part of what we've heard from the NACC when it talks to us about how it interacts with people who are referring matters to it is that also places a burden on their staff who are interacting with those referrers and with members of the public more broadly. Is that something that you've had to consider at the ICAC, and how do you manage that?
In terms of people coming to us, most of the referrals that we get are written rather than oral. We do our best to protect people, particularly through the peer regime. A lot of people who do come to us have concerns, and we try and address those as best we possibly can. It's fair to say that some are very distressed, and that adds to the pressure on our staff. We've given them training to deal with that and to respond, and some, unfortunately, can become very aggressive, and we have to deal with that as well. So there is a spectrum of complainants. We're cognizant of the difficulties that many of them are confronted with and the passion with which they want their issues addressed. We try and do our best in the circumstances to manage the different circumstances that each referrer presents.
Is there any particular learnings you have in that space that you think would be relevant for the NACC to be aware of, or for the committee to be aware of as we do this work?
Not specifically. We do have a register of people who are fixated. We have that reviewed regularly. There are people who present particular challenges. We don't like taking an approach which puts restraints on a person being able to approach the Commission, but from time to time it's necessary for that to occur. We do our best to respond to the issues that are raised. Obviously, some people are dissatisfied with the outcomes, particularly if we decide that we're not going to pursue a matter for whatever reason. We try and give them an explanation for that, as we're required to do under the Act. People respond differently to those circumstances.
Switching tack a bit, in this inquiry we are also looking at prevention activities, and I note that in your submission you've said that measuring the impact of corruption prevention and education efforts is difficult. Most anti-corruption agencies measure outputs such as the number of training sessions delivered, publications produced, and instances of advice given. How do you balance your reactive work, I guess your investigations work, against your preventative work? Is that something you try and quantify, or what's the approach you take?
The two are integral. We don't do investigative work without our prevention people being involved. Their job is to identify the areas where work needs to be done, to address those in terms of recommendations. Ultimately, when the investigation is concluded and the report is presented to Parliament, we write to the public officials and the ministers, as we're able to do under the Act, and request a response and a timeline for implementation. All of that is documented, it's published on our website, and it's pursued. And I report to the parliamentary committees about that. We don't give up. Sometimes we find it very frustrating if we don't get the responses that we've sought in a timely manner, but we nevertheless continue to pursue it and continue to identify it. We don't take it down from our website. It's all there so people can see what the outcomes are. The other aspect of it is that our Act requires us to have a collaborative approach with public sector agencies. It's not just a reactive approach, it's a proactive approach. So we have to go out to the agencies, we talk to them regularly, we ensure that they have the right culture and the right approach, particularly to reporting to the Commission. We're not as concerned about agencies that report too often. We're more concerned about the agencies that don't report or don't report enough in accordance with their activity, and we try and ascertain why. We look at their processes for being able to accommodate and to ensure that their leadership is one which is projecting the right approach in terms of ensuring that people are able to speak up. So it's a very intensive approach that we have with agencies, and if you look at our Act and our objects and our functions, you'll see it's heavily geared to that, and a lot of the referrals that we get from agency heads comes through that collaborative approach. This is not like a court where we just sit here in an office and we just expect people to bring packages of information to us. You actually have to go out and talk and to communicate with people and to collaborate with them and to develop trust so that they can come to you.
And so what you're saying is you make sure in doing that you are not just saying, okay, well, here's where we're getting referrals from, these are clearly the problem areas. You are looking more systematically to think, actually, it's probably... We look across
the sector. I mean, you can have an approach, I suppose, like a court, where people just come to you with filings or referrals. We don't take that approach. We are out there in the field, our education people are out there, our assessment staff are talking to agencies, they're doing regular review agencies. They look at where they're getting referrals, they see where they're not getting referrals, they say to people, look, relevant to the amount of activity that that you have. These statistics that this information that we're getting is not sufficient. We're particularly concerned where we see that we get more referrals about an agency than from an agency. That to us is a sign that things may not be going in the right direction, and we're onto them. And we get cooperation. I keep telling the agency heads, I recently was at the Board of Secretaries here in New South Wales, and I said, I'm not here to bring you down. I want to lift you up to higher standards. And we have to work together. Our Act requires that. In Section 12A, we have to work with agencies and we have to make them as corruption resistant as possible. Investigation is part of it, but it's not the end game. And at the same time, when we do an investigation, we do a report, we're out there projecting the lessons of that investigation, telling them what happened, explaining it to them in a simplified form, what happened, where the red flags were that were missed, what are the preventative recommendations that we're making, and so on.
And so to that point around, I guess, lifting up and that broader message of prevention that you're trying to put out there, are there metrics or is there research you have that has helped you refine or demonstrate the success of that approach?
It's very difficult to have metrics of that nature. The main metric that we use is the level of cooperation we get from agencies. Our Section 11 reports, which is the compulsory reports that we get from agency heads, are increasing. And that's a good sign because agency heads are taking the issues that we're raising seriously. They want help and they're asking for help and they trust us to deal with them fairly. And that's important. It's got to be a combined effort. You can sit out there like a crow waiting to swoop on the latest failing and see what that process unfolds, or you can get out there with the agencies and work with them together to ensure their processes and to ensure that we have a collaborative approach. Now, every investigation is different. It presents its different challenges. But we find this works. It's a change perhaps from that which the Commission has taken in previous years. One of the first things we did when we came in as commissioners was we adopted a strategic plan which prioritised that. It's also reflected in our legislation, which requires us to do it. We breathed life into it, and we're finding it successful. If you look at some of the PMES studies, they're available publicly. You'll see people have a greater awareness of these sorts of issues within their workplace. There's a greater willingness to come forward and to cooperate with the Commission and to report matters. That's all positive things. Now, corruption will never end. It's always going to be around. We do our best to address it in a holistic fashion, bearing in mind that we're only part of the solution because agencies themselves have to take big responsibility themselves.
All right, thank you. I'll hand over to the Deputy Chair.
Thanks, Chair, and thank you, Commissioner, for appearing before us today. I'd like to know more about the ICAC's intake process, that initial stage where complaints are received and assessed. It strikes me that it requires a mix of case management and client liaison on one hand and technical legal analysis on the other. How do you approach those two quite different aspects of triage?
Well, we have an assessments team which assess the various matters and report to an assessment panel. Now, there's a triaging process. Firstly, I should just make one point clear, and that is that any person can make, obviously, a referral of corrupt conduct to the Commission. For an agency head, the threshold at which they are required to make a referral is that there is corrupt conduct. Your Act, the National Anti-Corruption Commission Act, only mandates a compulsory referral to the National Anti-Corruption Commission if the corruption issue is serious or systemic. We don't have that in our Act, and nor do we require the agency head to identify the grounds upon which they regard the corruption issue as serious or systemic. So it's a different threshold. Ours is a much broader one. It comes into the agency, and our assessment people will prepare a report. If they need legal advice, that's available to them. But generally speaking, and we do have some lawyers in the assessment team, but they will assess it, and then it will be triaged. Some of the very straightforward matters are triaged, and they're documented, but they're not formally assessed in the sense of coming before the assessment panel. The assessment panel meets now once a week. It's chaired by one of the commissioners, and a decision will be made as to the course in which that matter will go. If the matter is to go to a preliminary investigation, or if the matter is to be referred back to the agency with the Commission's oversight of the investigation, that matter is escalated to the three commissioners. So the three of us will decide if a preliminary investigation is to take place. If the matter is, however, to be closed, it'll be closed. If the matter is to be sent to the agency, it'll be a decision made by the three of us in accordance with our Act. If it's a preliminary investigation, it'll go to one of the investigation teams. The investigation teams will carry out the preliminary investigation. If it's to be escalated to a full investigation, that again will be a decision made by the commissioners. I should stress that under our Act, we can investigate corrupt conduct. We are not precluded under our Act or limited to an investigation of serious or systemic corrupt conduct. That is a criteria which is in your Act, but it's not in ours. Our Act, however, does require us to emphasise or to give priority to serious or systemic. So it's left to us to make that judgment. And the reason why we prefer it the way it is under our Act is because sometimes you can investigate some things which aren't serious or systemic, but they become serious or systemic as you get into the investigation. And that's happened on quite a large number of occasions.
Thank you. That's really helpful. In terms of the time it takes for a referral to come in through that triage process, get assessed along the way, are you satisfied with the length of time that takes? Have you learnt something along the way? Is there anything that you can tell us about in terms of the technical expertise of those staff at that initial part of the triage process?
Look, we actually did get some assistance from the National Anti-Corruption Commission on the question of assessment, and we've worked together with them. You'll see that documented in their submission, and I'll give them credit for the contribution that they have made. But the timelines are actually listed in our annual report. You'll see the benchmarks that we have. We're meeting those benchmarks by and large. We're turning them around as soon as we can. As I said, we've now gone, because of the way we're prioritising and triaging them, we've gone now down from 2 meetings of the assessment panel a week down to 1. The reports are still fairly lengthy, but a commissioner does have the responsibility for reviewing those as the chair of the assessment panel. And again, if the matter is of greater consequence, it can be escalated to the 3 commissioners, and we'll make a decision if we're going to take it on or not.
Thank you. That's really helpful. And just finally on that topic, do you have any difficulty recruiting people into these triage and assessment roles?
Not that I'm aware of. We've actually expanded our staff quite significantly in the 4 years that I've been the Chief Commissioner. I'd like to think we're a destination employer, but there are some areas of the organisation that are more difficult to recruit than others, some of the more specialist roles that we have. We have a team of forensic accountants. That we have a digital forensics section. They're the more specialised areas of the Commission, where we have to take a very careful approach to recruitment to ensure that the relevant persons have the skills, and you have relatively greater difficulty sometimes in those areas than in areas, particularly legal, investigators and assessment staff. I think generally we do fairly well. I'd like to think we offer good benefits for our staff.
Yeah.
That makes us an attractive employer.
And just finally on this, where do you think the balance sits in this early assessment in terms of client liaison and legal technical expertise?
Look, the assessment staff are very good. The reports that we get generally are of very high quality. The number of occasions where the commissioners have disagreed with a recommendation of the assessment team to us are very small. I think it's less than 2%. And sometimes it's just a different approach. It might be that they want to close the matter because there's no corrupt conduct, for example, there's no likelihood of corrupt conduct. But the commissioner may think, well, look, there may be value in talking to a relevant public official. The conduct is not corrupt, but it's conduct which may require some modification in approach. They may recommend, for example, that someone goes to speak to them. And we do that very delicately so that we ensure that we protect the person who is referring the matter to. Usually it's done by, we pick a person to make that referral to who is somewhat distant to the individual, but who can still get to the individual so that consultation can occur.
Thank you. On a totally different tack now, I just wanted to ask you some questions around public inquiries, public interest. New South Wales ICAC can hold public inquiries if it's in the public interest to do so, and I know that there's specific things that you're required to consider in determining that. Could you talk us through how you make an assessment in practice and how you operationalise broad factors like the seriousness of the complaint or the benefits of exposure?
Well, first of all, I just need to correct a couple of things that have been said. But before I do that, perhaps I should go back to first principles. When you're setting up an anti-corruption commission, a body such as ours or the National Anti-Corruption Commission, you need to take into account very clearly what is it that you want to achieve. That's the first thing you need to do. And the second thing you need to do is work out, well, how far are you prepared to go to achieve it? Now, I heard one of the representatives of the Attorney General's Department, who was questioned by one of your members, say that we decided to go in this approach of limiting the likelihood of a public inquiry by restricting it to exceptional circumstances because we want to protect reputations, we want to protect prosecution action. There's probably a couple of others you could add to that. Political risk you could add health and welfare of witnesses and so on. And they're all matters that you can take into account. I suppose the difference with the New South Wales ICAC Act is that it's taken the approach that those are risks that can be managed. And what our Act seeks to do is give us the discretion to be able to make those judgments about what's in the public interest and what should go out publicly, but at the same time manage those risks. And if we're managing those risks, we have to be accountable for them, which is very important. So we have a public interest test. Now, first of all, before something comes to us to go publicly, it's got to meet the definition of corrupt conduct. It has to be tentatively corrupt conduct. The tests in our Act are different to the ones in the NACC Act. It has to be either something that is a criminal or constitutes or involves a criminal or a disciplinary offence, reasonable grounds for dismissal. It's got to bring the office into disrepute. There's a series of them in Section 9 of our Act, which aren't in your Act. So that escalates it and demonstrates that it's not just any corrupt conduct, it's conduct of a particular level. Beyond that, we have this public interest test that we have to apply, and our Act requires us to take into account, it's in Section 32, the seriousness of the matter. You'd look at, for example, is it criminal conduct? Is it not criminal conduct? Is it minor, trivial. There's a range of considerations that you factor in. You look at, obviously, the benefit of being able to expose the matter. You look at any undue prejudice to reputation. And you ultimately look at the view of whether the public interest in exposing the matter is outweighed by the public interest in preserving the privacy of the persons involved. So all of those factors are weighed. And then we have structural considerations. And what I mean by that is that at least 2 of the 3 commissioners, including the Chief Commissioner, has to agree to the matter going public. Now, what happens is that we get a report prepared by the team. We will, by the time that we have this, making that determination, we would have engaged in private inquiries, compulsory examinations of a range of witnesses, which will inform our decision making and factor in our assessment of the matters that I've referred to earlier. What then happens is, after we've done that, the commissioners will meet and decide, a document will be signed. And one other thing that happens, and we're not required to do this under our legislation, but we do it anyway, because the Parliamentary Committee at one point suggested it. I didn't think it was a bad idea. We give it to the inspector. We allow the inspector to read the report, read our decision, give us any feedback that she has in relation to the circumstances in which we decided to exercise our decision. And then we have the public inquiry. Someone's allocated to preside. The scope of the inquiry will have been determined by the Commission, and the public inquiry takes its course. But even, and this is why I go back to this point about controlling risks, yes, there may be questions of reputation, there may be questions of health and so on, but you can manage those because we have non-publication orders we can make. We can at any stage go into, take the public inquiry into a private session, which we've done. We can restrict access. Sometimes we've deactivated the live stream to make it more comfortable for the particular witness if there's issues that arise because of that exposure, bearing in mind that our public inquiry, sometimes our live stream can get up to 17,000 views. I think that's the record we've had so far. So we try and manage these sorts of matters, and we're acutely aware of reputations and the need to protect reputations. Reputations are important. We're not here to trash people's reputations, but we are here to get to the truth and to establish what happened and to use what we have exposed as a vehicle for not only keeping people accountable, but also making the case for change.
Thank you. That's a very useful stepping through the process. I'm curious, Commissioner, if you were required to have the additional test of exceptional circumstances, how would you see that as changing the process that you just described?
Well, we don't have the test of exceptional circumstances. And people have asked me that in the past. New South Wales Court of Appeal in another case, I think it's San Rumble number 2, 2007 NSW CA 259 at 59, said that the word exceptional can depend upon the relative numerical frequency, but also on being not what would ordinarily be found in a particular qualitative circumstances. That's the New South Wales approach, but it's different to what I understand the Court of Appeal has decided in Victoria in the case of ICAC. They took a much more restrictive view. But we don't have that. But what I will say to you is the number of public inquiries we do is not huge. In our first year as commissioners, there was 1 public inquiry. In our second year as commissioners, there were 2. In our third year, there were 2. This year we've had 2 already. There'll probably be more. But when you look at the number of referrals that we get into the agency, it's a very small proportion. Now, if you look at it numerically, you'd say it's exceptional. But that's not the way we look. We don't apply that test. We apply a public interest test.
And I guess just for clarification, you and I now we've been talking about public inquiries. Under the NACC Act, we talk about public hearings. Would you just be able to describe where you see the difference between a public inquiry versus a public hearing?
We have public inquiries. That's what our Act says. Whether it's the same as a public hearing, which is what the NACC Act says, I haven't examined it. My view, and I don't have experience at the National Anti-Corruption Commission. I've read their annual report in preparation to giving evidence today, but I've read the cases that they have. And with the possible exception of Operation Myrtleford, I would not have taken the view that the other matters that the National Anti-Corruption Commission has done to date were matters that, in our case, would have warranted a public inquiry. We're not an alternative justice agency. I need to make this clear. We're an anti-corruption agency, and we're there to look at serious and/or systemic corrupt conduct. If cases involve single instances transgression, you have to consider whether it's just appropriate to prepare a brief and to send it off to the DPP, as the National Anti-Corruption Commission has done on quite a large number of occasions. You'll still get the exposure at the trial level if it proceeds at that point. The benefit to us is that we're able to deal with matters in a different way, in an overview way, which could address an issue, whether it's nepotism, cronyism, procurement fraud or whatever, in a way that perhaps a court case which is looking at criminal conduct cannot. And it can also make recommendations for change. And I think that's the advantage of the public inquiry process. It supports the case for change and it demonstrates the need for change. And as I said, the various risks that have been referred to in the Attorney General's submission, but also the other ones that I've mentioned, are matters that our Act and our processes seek to address in a different way. I'm not saying they're unimportant, but they can be addressed in a different way.
Thank you very much. Thanks, Chair.
Thank you. Senator Shoebridge.
Oh, thanks, Chair. And thanks, Commissioner, for your assistance again. You've spoken previously about public hearings having an educative role, so that the public can see the work that the Commission is doing and anti-corruption measures are disseminated more broadly. I might ask you if you could expand on that, your understanding about that sort of public engagement role of public hearings, and that, you know, sometimes that leads to the ICAC being criticised. More often it leads to the ICAC being discussed as a relevant institution in New South Wales. But would you mind speaking to that briefly?
Well, one of the things that our public inquiries do is result in more referrals into our assessments division. It's when we make an announcement of a public inquiry, when the public inquiry takes place, we just see a spike in the number of people who are coming to the Commission. Now, that could be just because of the raising of the profile. It may be the issue. It may be the specific case. They say they have an additional piece of information that they can provide. But we get that spike, even more so these days with our live streaming process. Beyond that, we get interest. So, for example, we did an investigation last year into school infrastructure fraud. It was called Operation Landon. We delivered our report to Parliament. In the lead up to the publication of that report, we got a number of requests from agencies, can you come around and give us a talk about that? And we did. We're still doing them. I've done a podcast on it. My colleague, Commissioner Lakatos, is presenting in a seminar with the Public Service Commissioner. There's been requests for people outside of the public sector to be able to tune into that. We're getting a lot of interest in relation to these matters, and that's good. So the public inquiries do generate a lot of interest. Now, I don't want to be critical of anyone, but I do notice Operation Myrtleford was done in private. Maybe reasons for doing that, but one of the things that happened is the National Anti-Corruption Commission was criticised in relation to what some people, rightly or wrongly, viewed as the paucity of the findings. One of the benefits of a public inquiry is that people can see the evidence. They can see whether the conclusion is justified by that evidence. Now, as I said, there are risks associated with that, but you need to be able to manage those risks. And I hope that people accept that with the benefit of the experience that the New South Wales Commission has had over 37 years, we're doing that a lot better these days than perhaps was done in the past. I didn't come to the ICAC 4 years ago uncritically. I thought some of the investigations that the ICAC had done in years past were low-hanging fruit, to be perfectly frank. Now I think we're on a much better trajectory because of the better experience that we have in ensuring that our public inquiries provide value to the public sector and to the broader community in an understanding of corruption issues.
One of the other benefits you've spoken about in the context of public hearings is not just that sort of broader educative role or interest role, where the issues that you're raising in relation to one corruption inquiry may spark interest in corruption proofing in other government agencies who may be addressing similar issues. You've also spoken previously about how the public hearings themselves can actually bring forward relevant evidence related to that hearing. Is that still the experience in ICAC?
Yes, it is. And look, I don't really want to harp about particular investigations, but in Operation Keppel, we were criticised, by the way, in Operation Keppel. That's the case that dealt with the former member for Wagga Wagga and former Premier. But no one brought that matter to the Commission in a box with all the relevant evidence to tell us what happened. That required painstaking work by the Commission. It took a public inquiry to start it, to get more evidence, which resulted in more evidence having been forward. It was a process, and we had to use every power that we had in the ICAC and the ICAC to be able to uncover what happened. Now, it's not the only investigation. That matter started off not at the New South Wales Parliament. It started off at Canterbury Council when the Commission was looking at a situation involving a developer, developers and an MP and a couple of councillors. And out of that, the Commission started to look at the MP and then started to look at the former Premier. Now, none of this is pleasant. Please, we don't celebrate this stuff, but nor do we turn our eyes away from it. Sometimes we come across things we'd prefer not to see, but that's the world we live in. And the Commission will not turn its eye away. We're not here to bring people down, okay? But if we see bad conduct, we will call it out.
It's pulling on a thread, and you're not quite sure where that's going to lead.
And our thresholds are such, and I have some sympathy for the National Anti-Corruption Commission. The Attorney General's representative said that they're happy with the legislation. Well, that's a matter for them. But our Act allows us more flexibility in terms of our capacity to investigate, to receive referrals, and to take the course that we do. We have a great deal more discretion, I consider. I acknowledge that. But let me also say this, that we accept the responsibility that goes with it to be accountable for it.
Could I ask about your role? I think it was redefined a few years ago as, from memory, it was Chief Commissioner. Your role was redefined as, well, the role you now occupy was the statutory position was redefined how the commissioners all worked together. One of the concerns I have, I'm not asking you to adopt it, is that there was a very dominating presence in the National Anti-Corruption Commission, which led to a dominance by just the Commissioner. I'm not asking you to adopt that, I'm just saying that's my view. But can you talk about how maybe the statutory arrangements and or the culture in the ICAC, how that decision-making is made between you and the other commissioners?
Well, first of all, I inherited this model when I came here. Peter Hall, who had been my predecessor, had worked with the three-commissioner model. You might recall, I think you might have been in the New South Wales Parliament at the time, that there was an issue which arose in the Canine matter. There was a review done by the then government. There was concern in relation to some of the investigations that ICAC did under our predecessor, I think it was Commissioner Megan Latham, and a view was taken that we should move to a three-commissioner model in one of those reviews, and Commissioner Latham was asked to reapply for her position and she declined. Now, I'm not condoning any of those circumstances, but the three commissioner model developed out of that. The concept of it was that it would result in a broader view of things, different perspectives being able to be taken into account and so on. Now, the previous commissioners were on record. They said that they had some difficulties with that model. Two of them said that they should go back to a single commissioner model. One of them was happy with the three commissioner model. Bruce McClintock, who I think might have been one of the persons who recommended the three commissioner model, suggested we go back to a two commissioner model. LEC, which started off as a three commissioner model, is now back to a two commissioner model. I haven't paid too much attention to any of that. What I have done is tried to make the three commissioner model work. And that means that I have to acknowledge the skill and the expertise and the perspectives of my colleagues. And that's what I've sought to do. And I have to say we haven't had any divergence in terms of particularly the public inquiry issue. We haven't had, a 2-1 decision made in relation to whether we should go public. And we talk about these issues, we discuss each other's perspectives, and we try and work through the differences. Now, I know the Act says that the Chief Commissioner can override the others on other matters other than public inquiries. In practice, we work collaboratively.
And do you think in your experience, that there's a statutory obligation on the question of public hearing for there to actually be that discussion amongst the three of you and to flesh out the issues, amongst you? If nothing else, that statutory requirement kind of compels you to have those kind of substantive discussions. If you like, it surfaces the issue very clearly.
About having a public inquiry?
Yes.
Look, as I said, on public inquiries, the cases largely select themselves. It's not as they're largely self-selecting. You've seen the kind of work we do. It's not single instance transgressions. It sometimes goes beyond one agency to multiple agencies. It involves systemic corruption almost invariably, or high profile corruption. And that's what we do. And it requires a lot of skill on the part of our staff and leadership on the part of those in the positions that I and my colleagues occupy to ensure that we do that. So I don't want to suggest that the three commissioner model results in a divergence of views amongst us in that regard. What I do think it does is it provides a greater sense of reassurance to the outside community that those decisions are being made in an appropriate fashion.
They're not idiosyncratic. They're not personal.
They're not idiosyncratic.
There's a structure and a process.
I'll give you an example, Senator, of what I'm referring to. You will recall in the Keppel investigation, where the Commission decided that we would go to a public inquiry in relation to the former Premier, and it related to some matters that were sensitive. I have to be frank.
I recall.
Sorry?
I recall the evidence. I recall the nature.
Now, the Commission, I wasn't here at the time, the Commission obviously had to make a decision on that and balance the relevant public interest, and it took a lot of work on the part of my predecessors to be able to do so. But ultimately, the decision which was taken, I think, had a greater level of public acceptance because the three commissioners were in agreement on that issue, rather than if one person was involved in that issue. And ultimately, when the report was handed down, there was a lot of criticism. We were referred to the inspector. We were taken to the Court of Appeal. We survived that criticism. That report is being used extensively in our education activities, particularly with members of parliaments and other public officials, including local government.
So, I mean, of course you can have, you could voluntarily put these structures in place in any anti-corruption body if you have more than one commissioner. But there's a lot of, I mean, you've heard it, you've heard it even, even in the course of this inquiry, but you would have heard it more generally in the discussion at a federal level, this kind of the horrors of public hearings and the damage, etc. But in terms of like a structural reassurance, a kind of structural long stop of it, having some of that collective decision making as a requirement before public hearings are held, there is a public confidence element in that too, isn't there? It does give that assurance.
Well, I think it does, provided the people that you have are the right people. See, Papua New Guinea established an independent commission against corruption with a 3-commissioner model, and they've been fighting each other in courts. That hasn't worked. So it can work, it can fail. It depends upon the individuals who are involved making sure that it works. I've done my best to make sure that it works. And it's for others to judge our work, the quality of it.
And so one of the other things that comes back to is the recruitment process and ensuring that there is rigour in the recruitment process, and you're looking for these kinds of attributes in commissioners, not just some kind of purity of professional experience, but perhaps how they'll work collectively, what kind of leadership they'll show. Those kind of recruitment elements are kind of also critical in an anti-corruption commission.
Well, I went through a recruitment process. Myself and my colleagues did, and we were all recruited in the same batch. So I knew one of our commissioners, Commissioner Paul Lakatos. In fact, I recommended his appointment to the District Court when I was the Attorney General, so I knew him very well. Commissioner Morell was the former Chief Justice of the ACT. I knew her. I appeared before, I think, on a couple of occasions when I was a barrister. But I didn't have the same level or intensity of interaction. I didn't have a problem with either of them. We just made sure the relationship worked. We had a discussion when we started. You bear in mind, we came into the job with no transition. We had 5 uncompleted reports, which we had to get out, including some big matters, which we hadn't heard any evidence. We sat down, we got those reports done. We established our relationships. We set our new strategic plan within 6 months, saying this is where we're going. We then had to use that to go to government to get the funding to be able to ensure that we can deliver on that. We have gone overboard in terms of our transparency. I'm quite happy to detail what we've done in that. We don't look at the Act or the Annual Reports Act and say, this is what we have to do. Forget that. We put more in than we have to. As I said to you, I gave you an example. I give the Section 32 report to the inspector. No one says do it, but I don't see a problem doing it. What's the problem doing it?
Thanks, Commissioner. Thanks for your evidence today. And as a New South Wales resident, can I pass my gratitude on to you and the whole team at the New South Wales ICAC? It gives me a level of assurance, and I genuinely appreciate it.
Thank you.
Thank you. Dr. Garland.
Thank you very much, Chair, and thank you so much for the evidence so far. Obviously, community trust and support for bodies such as ICAC and NACC are very important. Now, I note that in your submission you reference a community attitude survey which ceased in 2015, stated that happened due partly to cost and partly because the results were no longer producing valuable information. Just interested in having that drawn out a little bit more, if you don't mind, particularly that latter part in terms of why that survey and the information it garnered was deemed no longer useful.
Well, I wasn't around then, so I can't comment directly on the report. That's certainly what my officials have said. I have raised that. I noticed that the National Anti-Corruption Commission did do a survey. The take-up rate of that and the results of that are documented in their annual report. You can read that. I'd like to think that the issues that, however, that the Commonwealth survey identified in terms of ethical concerns in the public sector are the sorts of matters that we have picked up anyway through our own process of the referrals, matters that have come in, but also through our survey of PMES results. What we do, it's a less expensive way of being able to do it, is if we do need survey questions asked of the public sector, is try and use the PMES study, which is an annual study, to get that kind of information and to be able to view it and it also gives us a cross-section of the differences between the various agencies.
Thank you very much.
All right. Thank you very much for your appearance today. If you are being asked to give copies
Sorry, I have one more question with the Commissioner, if that's all right.
That is all right.
By the way, if you ever want to come and visit us, you're welcome to. I don't have anything to hide here if you're interested in
We appreciate that offer. Thank you.
They all say that, Commissioner.
Well, I've been saying it for years. I've had the parliamentary committee here a few times. In fact, I suggested it to Commissioner Brereton, and I don't know if he took it up. But anyway, you're welcome if you want to come.
Thank you. Deputy Chair, you said you had an additional question.
Yeah, I do. Thanks so much, Chair, and thank you, Commissioner. Look, you are in your role for your highly specialised investigative and decision-making expertise, but you're also head of an organisation. Obviously, you've got a CEO who's responsible for day-to-day management, but you're the leader. You set the tone. How do you balance and prioritise those two sides of your job, tone, culture, as well as that specialised knowledge, and has that changed over the course of your appointment? Is there anything that you could reflect on that?
Well, first of all, our Act is different to the NACC Act. Our staff are not public servants. They are state employees, and we're under a separate award. And I'm the employer here under our legislation. Under the NACC Act, the head of the agency, I think on terms of staffing, is the CEO and the head of APS, and they're all APS staff. So it's a difference as far as that's concerned. A lot of the staffing powers, however, are delegated to the CEO and the executive directors of the various divisions. There's certain matters that are reserved to me under those instruments of delegation, and some things in the statute are exclusively mine. For example, the appointment of the CEO, unlike your Act where the CEO is appointed by the government. So there is a demarcation, and we do also have policies, and the policies delineate what needs to come to me and what comes to the CEO. I have a very close relationship with the CEO. We have meetings, we discuss issues. Although the staffing issues actually fall under my responsibilities, I do raise those, and I have delegated a lot of staffing responsibilities to the other two commissioners as well. So that's how it works in practice. But to a very large extent, the CEO manages a lot of the recruitment matters, for example, and staff discipline. If there's issues of that nature, I'll be advised about those. We routinely, if those sorts of issues arise, I make it a point of ensuring that the inspector is informed, and the process, and we keep the inspector informed about all of those sorts of matters. I should just indicate to you that across our decision making, our minutes of our meetings are routinely sent to the inspector. That includes our management meetings, our investigations meetings and our prevention meetings. They all go to the inspector, and she's entitled to ask us any questions that she wishes. The memorandums of understanding that I have with other agency heads, we make as many of those public. They're available on our website. One of the ones that we make public is our relationship with the inspector and the information sharing that we have with that, so that you can view that as well. That's where I get back to the point. We have to be transparent and accountable. And we're proactive. We're proactive in our communications with both the inspector and the parliamentary committee. The parliamentary committee, I've asked to see them. I want to have an informal meeting with them to discuss a couple of issues. They've put some time aside in a month's time for that to occur. So to get back to your question, I may have deviated slightly. It's a relationship which works, it's functional, and I'd like to think that the Commission's standards are embedded in the policies that we have, which not entirely but largely mirror that of the broader public sector, but we do that voluntarily.
Thank you. And I guess just so I'm clear, things like sharing your minutes with the inspector is a really good example of transparency. Proactively coming to the Oversight Committee is a really good example of transparency. And as I've understood your answer, they're policies that you've set up. You're not obligated to do those things. Is that something that you've done as a leader? Is that the culture that you've created? And is that something I'm aware that your term is I think, if I'm correct, not preempting anything, but I think your term concludes next year. Is that something that you would see as a culture that would transfer to the next commissioner, and something you would recommend that did happen?
Look, I don't know what approach will be taken by our successors. I can't predict that. You understand my background coming to the Commission. It's perhaps different to that of my predecessors. And I'm not critical of them. Each person makes their own contribution to the functioning of the Commission, and I'm indebted for many of the things that my predecessors have done, and I acknowledge that. But I came into this role with some history. As a student and as a young solicitor, I lived through the days where we had a High Court judge on trial, where we had a Chief Magistrate who went to jail, where we had a Royal Commission into the former Premier, where we had serious breakdowns in public trust, which resulted in a series of changes, including the establishment in 1988 of the Independent Commission Against Corruption. I remember that period before, I remember the period after. I was the chair of a parliamentary committee where I worked under two commissioners, one of whom is now deceased. The first of those commissioners, I have to say, I found very difficult to work with. I wasn't getting information. I felt that the committee's job was basically to listen to reports and clap. That was an experience that I had to live through. I put a report to the government from the committee recommending the establishment of an inspector. It was not immediately picked up. It was picked up in a subsequent report where Bruce McClintock recommended it, but I was the first to actually raise it. I thought that it was important. Now, having gone through that history, having said that this is what needs to happen, having looked at ICAC over that period and seen where in some instances it's received justifiable criticism, I've sought to take an approach to the agency which differs from that of some of my others. I hope that people see that that approach has drawn some dividends, and I hope that it continues. I can't predict what will happen in the future. I will return to the court as a judge when my term finishes, but I hope that people see that I've done my best to ensure that the model works and that the agency delivers for the taxpayers and the people of the state.
Thank you very much. That really shines a light, I think, on how you have worked to establish trust and transparency, and how your background, your attributes, the culture that you create, then transmits into how the ICAC operates. It's really helpful.
I should just make one comment, Senator, and it relates to a question, sorry, Ms Haynes, that relates to something that you said. I have a very low tolerance for any suggestion of impropriety in the Commission. It goes to the inspector. I don't manage it myself, usually. I let the inspector know, and I keep her appraised of it. I don't look at the Act and see what the inspector's powers are and say to her, well, this doesn't fit within your powers, this fits in your powers, or that. I don't think that's not a way the relationship should work. I have no interest in seeing the Commission fall into disrepute. None at all. If we're asking other agencies to conduct themselves in an ethical and transparent manner, we should as well.
I couldn't agree more. Thank you very much, Commissioner. Thanks, Chair.
Thank you, Commissioner. Thank you for your evidence today and
Wish you well with your inquiry.
the time you've taken. If you've taken any questions on notice,